and I've known Ron for a number of years. Mainly, we first met through BNI, and then we have a similar. Ron and I are incredibly similar. We both follow the North Melbourne Football Club, and I know we've got a couple of Collingwood people in here. So we both have the same issues, I guess, and we're both going through therapy on that one. So Ron and I have known each other for many, many years, but I've actually been involved in a couple of transactions where rent roll sales, where Ron's firm have been involved as well. So it was really an easy reach out to be able to touch base with Ron and ask him to, or invite him to actually join us here at the Real Estate Resource Group. There's Ron's details. We can so maybe someone can actually pop those into the chat. I think Nick's doing that, so thank you. And Ron, I'm going to be your finger pusher. So if you can just let me know when you want me to go through to the next slide, I'll certainly do that. And take it away, my friend.
Appreciate it. Thanks, Michael. So if you just want to go to the first slide, which is really the first topic, which is very topical, and that is the transition from working at home back to the office. So in Victoria, and it's happened in other states where people have been in lockdown that's been mandated, certainly about a month ago at the end of February, the Victorian government removed the recommendation for employees to work from home. And now we're faced with, I guess, a bit of a transition of employees back to the office and to really see what it looks like. I know even in the breakout room we were talking about this, where some employees and you know, certain employers as well are looking for a bit of a hybrid model, that is to work partly from home, partly from the office. So it's really important, I guess, for businesses to assess what works for them, what works for both parties moving forward. So some real estate agents in particular might be able to adopt that hybrid model, but it is still important for employees to return to the physical workplace as well, where there's a lot more collaboration, mentoring, and long-term profitability. And again, I saw in the chat a lot of people were talking about that issue of mentoring and bringing staff up to speed. So, Michael, if you want to just go to the next slide, and that is, you know, some of the considerations of the employers, and that is really the employer really needs to make sure that they're meeting the, amongst other things, the OH&S, as well as current vaccine obligations, which I'll touch on a little bit later. And the other thing that the employer has to also have regard to is employees that are looking to actually amend their hours of work or transitioning, as we've said, being permanently from home or that hybrid model. So employers have to manage their own obligations under any relevant award and also under any relevant employment agreement that they've got with the employees. They've got to then consider requests for flexible workplace arrangements with employees and also whether the business has actually got reasonable grounds to refuse those requests. And I'll touch on that in a little bit more detail shortly. And also considering whether to actually permanently alter the employee's contract of employment by agreement as well. So if you want to go to the next slide, please. I touched on the award. So it's in Victoria, it's the Real Estate Industry Award, where employers do actually have an obligation to consult with employees in relation to any major employment changes. And there are, if there are any changes that the employer is seeking to make, that could include things like hours of work, place of employment, change to working hours, that really needs to be discussed between the employer and the employee, and really to work out their response before actually making a final decision on any of those issues. I've set out really some of the requirements of the award, but the employer really needs to engage in the process. It needs to get employees' response to any changes, and our employment team here at Tisher FC Law have actually seen quite a number of cases where they've found that the employer has actually contravened the award, and they're really only paying a bit of lip service to their consultation obligation. So it really is very important for an employer to take the legal requirements quite significantly. And again, please reach out if anyone's got any questions on that as well. Michael, if you want to go to the next one, Section 65 of the Fair Work Act. It's a Commonwealth legislation, so it applies quite across, right across the board in Australia. And in a real nutshell, it says this, that if you're an employee, you've worked with the same employer for at least 12 months, you can actually go to your employer and request flexible working arrangements. That includes things like, as we've said, change to hours, location of work, and pattern of work. So, for example, job sharing or a split. The slide actually does show which employees can actually make those requests or the reasons. And they are, for example, if you are a parent and you've got responsibility to look after a child, you are a carer, you've got a disability, you're over the age of 55 years, or you provide care and support to household members. So that's in the legislation. If you qualify for those, then you can actually make a request for flexible working arrangements as well. So Michael, if you want to just go to the next slide after that, how does the employee make the request? So an employee has to make a request in writing. That's very important. They've got to explain what changes to employment they're asking for, and also the reasons for making the change. So we've given the example there in the slide that an employee will send an email to their employer looking for a hybrid structure of working partly from home, partly from the office, for example, to meet carer obligations. So then the next thing, which is really very important, is what should the employer do when they actually receive that request? And as we've mentioned there in the slide, the employer, when they've received the request, must provide a written response within 21 days. And that's got to outline whether or not that the employee's request is either granted and accepted or it's refused. Michael, if you want to go to the next slide. Some of the reasons why the employer can refuse, the legislation says employers can only refuse a request if they've got reasonable business grounds to do so. And when the employer writes back and responds to the employee's request, they actually have to provide the reasons for the refusal as well. So that slide gives a few examples of grounds for refusal. Michael, if I get you to go to the next slide then after that, please. And that is implementing the flexible working arrangement. So in circumstances where both parties actually do agree to implement a flexible workspace arrangement, we recommend really that firstly, the arrangement is in writing and it's signed off by both the employee and the employer. Both parties obviously should be very aware of their obligations and what's expected of them going forward. And the other thing that we would normally recommend as well as lawyers and really advising both parties is just maybe to put the arrangement in on a trial basis to see whether it works for both parties, and then review it after a relevant period of time, particularly to make sure that the employee is still satisfying their obligations under the arrangement and they're still providing and carrying out their obligations as well. The other thing also from an employer's point of view that we often recommend is actually to include a provision allowing the
Looks like we might have lost Ron there. We'll just give him a moment or two to come back.
So as we go through there, have we
well, any help?
There we go. Ron, sorry, Ron, we just lost you for a moment there, and you dropped out. So we're back. We're about to just go through. I think everyone's just dropped their mouth a little bit to understand some of this. So I thought someone maybe have cut your Wi-Fi, but over to you again, my friend.
All right. No, that's okay. Did you hear that part about what we were recommending in terms of making it a trial basis first, and also to have the employer the ability to terminate if it's not working as well? And I was going to say again, because there's so much of all of this that's required and it's covered by legislation, it really is a good idea to get legal advice on those things, and we can assist with advising and drafting any relevant documents. So if you want to go to the next slide, which actually is actually amending the employee's terms and conditions. So if ultimately the employee's terms and conditions of employment are going to be permanently amended, that has to be done by mutual agreement with both parties. We also do recommend that it be documented, signed off in writing as a formal agreement. Most employees would have either an employment agreement or a letter of employment that they might have signed off. What can happen with any permanent change is either a variation to the existing employment contract, or alternatively, you can actually implement a brand new contract as well. The other thing really is that if there is, however, a significant change to an employee's current employment, for example, a change or reduction in the hours, and that was done unilaterally by the employer, that could actually be deemed as a termination of the employment. And if so, that might trigger things like paying off, paying out employees' entitlements and everything else as well. So it really is, again, we keep talking about consulting. Both parties really do need to consult. So there's quite a plethora of information there. And as I said, very important to get legal advice. This is really just general in nature. If I can then go on to the next slide, which is really the next topic that I just want to touch on, and that is the COVID-19 vaccine mandates. And what we've got is that in Victoria, at least, the current orders and the current mandates have been implemented since February. They're set to terminate in April, and there's a possibility or a good probability that it might actually be extended as well. And employers have already been dealing with these orders for several months, and that is really that if you aren't vaccinated, then the mandate is that you can only work from home, and it's an obligation of an employer not to actually allow a person that's unvaccinated to return to the place of employment. The employer has to collect records of employees to ensure whether or not they are vaccinated or not, or alternatively, either they are fully vaccinated or they're exempt. And it's only in those two circumstances that you're allowed back to the office. Now, there's a little bit of a grey area now with all of these boosters as to what's actually is a definition of being fully vaccinated. At the moment, the current definition is that if there's a 1-dose COVID vaccination, you need the 1 dose. If there's a 2-dose, which is primarily what's happened here in Australia, then you've got the 2 doses. So it doesn't actually at this stage talk about boosters. So even though boosters are available, the current definition of being fully vaccinated is either, as I said, a single dose of a single dose vaccine or 2 doses of a double vaccine. Michael, if you want to just go to the next slide now, which is...
Sorry, Ron, just on that one. We've got a couple more minutes we'll just, and then we'll start to move on to the next one, if that's okay. Sorry, mate.
Yeah, definitely. Yeah. No, that's okay. So really, the next one speaks for itself, which is whether or not an employee can refuse to work with an unvaccinated colleague. And we've got no in certain circumstances and yes in others. I think the next slide, Michael's the one that we're all sort of talking about, and that is what happens if an employer doesn't follow the current orders. The big one really is the last one, which is that if an employer allows an unvaccinated worker who doesn't have an exemption onto their site, they actually face a penalty of up to $110,000. And I think, Michael, you quipped earlier that really that's a great way for the government to claw back some of the money that they've lost. So that's really one of the things. And the other point also is employees also face potential fines if they provide false or misleading information regarding their vaccination status as well. The only final slide that I just wanted to touch on really was the occupational health and safety law. So quite apart from the specific mandates and vaccinations, employers also do have to follow occupational health and safety laws. And one of those really includes preventing the risk of exposure to COVID-19 at work. So everyone has to have a COVID safe plan. We have ours, for example, on our intranet where it's very visibly available. That's something that definitely ought to be done by employers. And really the expectation is that employees need to follow that COVID safe plan as well, and in addition to complying with government's pandemic orders. There's a lot to talk about, but that's really the main things I wanted to touch on today as well, Michael.